Order. Welcome to this afternoon's session of the Justice Select Committee. We're starting a few minutes late, for which apologies to those attending, particularly our witnesses. But this is the latest session on access to justice, and we have some witnesses in two panels that we're going to hear from in a moment. I'll ask them to introduce themselves. But first, the members of the committee will give their declarations of interest, starting with Warrinder Just.
Hello, I am Warrinder Just, Member of Parliament in Wolverhampton West. I'm a solicitor, but not practising at the moment. I'm a member of various APPGs, as well as being a member of the Central Executive Council of the GMB Trade Union. I'm
Andy Slaughter. I'm the chair of the committee. I'm the Member of Parliament for Hammersmith and Chiswick. I am a non-practising barrister. I'm a member of the GMB and Unite Trade Unions, and a patron of two justice-related charities, the Upper Room for Ex-Offenders and the Hammersmith and Fulham Law Centre.
Hello, my name is Tessa Munt. I'm the Member of Parliament for Wells and Mendip Hills in Somerset. Everything's as per the Register of Interest, but I will just highlight the fact that I am a director of Whistleblowers UK, which is a not-for-profit organisation, and I'm also the vice chair of the all-party parliamentary group for penal affairs. Thank you.
Hello, I'm Vicky Slade, Member of Parliament for Mid Dorset and North Pool. My register of interest is, as per the record, I have no relevant interests to this committee.
Afternoon, Matt Bishop, Member of Parliament for the Forest of Dean. My interests are on the register, but just to highlight, member of GMB Trade Union, and my previous occupation was a police officer.
Hello, I am Sarah Russell. I'm a Member of Parliament for Congleton. I am a solicitor specialising in employment law, although I am not currently practising. My interests are per the register, but I'm a member of the USDOR and Community Trade Unions, and I am chair of the Access to Justice APPG.
Thank you very much. We have two panels this afternoon, each for about 45 minutes. And the first panel is Tom Hayhoe and Dr. Liz Curran. Would you very briefly like to introduce yourselves?
Well, I'm Tom Hayhoe. I chair the Legal Services Consumer Panel. I have some interests in professional regulatory law, sitting as a chair for one professional body and the chair of the board of another professional regulatory body, but neither of which are involved in the law.
My name's Dr. Liz Curran. I'm an Associate Professor of Clinical Legal Education at Nottingham Law School, Nottingham Trent University, also Honorary Professor of the Australian National University College of Law. I have been a practising solicitor but non-practising here in the UK for over 30 years, and my area of research expertise is access to justice, health justice partnerships, and I evaluate effective legal services.
Thank you very much. I mean, if you've followed this inquiry so far, you'll see that we're looking at access to justice in broad terms. We have looked at legal aid and legal advice. We're now looking at broader and alternative methods of access to dispute resolution, access to courts and tribunals, funding for those, and finding a curious mishmash and finding it difficult for consumers to access, and we think that you're people who could probably shed some clear light on that from a consumer's point of view. So if I could start, again, please feel free to answer either of these questions. This one I think is primarily directed to Tom. In your written submission to this inquiry, you state that the legal services market is confusing and fails to provide consumers with the information they need. What are the main reasons why the legal services market may serve the general public poorly? And has the general public's experience of the legal services market changed over time, and what's driving those changes?
Well, I think if we start off with the issue of the complexity of the market, I sometimes make a comparison between my experience retaining legal advice with calling a plumber. There's an acute asymmetry in terms of the knowledge and information. Even though I happen to be married to an ex-lawyer, but if and I don't really know what it is I'm purchasing, I'm not really sure what value for money will look like. And similarly, if I'm dealing with a plumber, I don't know whether I've got value for money, whether the problem has been properly solved for maybe years later when nothing further goes wrong. And it's an issue which applies across all sorts of professional services, but it's particularly challenging in the case of legal services because actually the impact on us can be so acute and so severe. If we then look at the complexity of the market, we have all sorts of different types of lawyer. And we've got one of the issues which is being addressed by the appeal court only yesterday and tomorrow in relation to the legal executives and paralegals and their supervision when they're delivering their sorts of services. But there are certain activities where I now know that I would probably be certainly be better off dealing with a Silex lawyer who is a specialist in a particular area than a sort of, I'll be cautious about the language and I can't think of anything better, but someone who is a sort of jack of all trades, high street solicitor with who, in what's quite a difficult market, desperate to get any bit of work that they can do in relation to the work I do outside my legal services consumer panel work as chairing the taxation disciplinary board. We get worried with the tax professionals about someone who strays beyond their real area of competence when they're giving tax advice around maybe supporting, maybe it might be probate, might be estates work, or maybe something where they're not even a specialist at all. So you've got questions, who do I go to? The classic is you would be a probate. You might go to an accountant, you might go to a Silex lawyer, you might go to a licensed conveyancer, or you might go to a solicitor. And so there's those sorts of things which make it quite difficult for the consumer. So I think there's that complexity about the nature of the profession, and then overlaid on it, there is a complexity about the way that regulation takes place. And one of the issues which is kind of in the ether is, should we be doing more by way of regulating for activity as opposed to explicitly a professional? And so one of the things which we're keen to see over the next few years is the MOJ reviewing the regulatory structure and framework.
Liz, do you want to add anything to that?
Yes, I would agree with Tom, and I would go further. The research tells us that people have very limited legal capability, and many people don't know they have a problem and that it's capable of a legal solution. So that adds another dimension to this complexity. And the other issue is the unnavigability of legal services. It's very piecemeal, it's very fragmented. What I don't want to do is to go over old evidence that you've heard before the inquiry. I want to have a very problem-solving solution focus to my responses. So I and my colleagues, Professor Jane Jarman and Professor Jane Ching, wrote a report, Regulatory Leadership on Access to Justice. It talks about the complexity of the regulatory environment, and it looks at things from a consumer perspective or a people-centred perspective in terms of the unnavigability, the lack of legal assistance services. And that report provides us with multiple and many different solutions that have been used and done to great effect in other jurisdictions like Canada and Australia. And not only does that report flag them, but it tells us how they went about it, and part of the research was empirical data from those people about how they managed to make a difference and change culture. I think the problem here is that we have a really siloed, fragmented system that serves lawyers, I'm sorry to those on the panel, but serves lawyers rather than the consumer. I think we need to focus on what people need rather than what lawyers think they need. And I think that the legal profession needs to do a lot more work in terms of actually breaking down the barriers that legal jargon, self-promotion. I know they need to make money, but often there's opaqueness around their, as you said, Tom, fee structures, what services they offer. I was on the board of Nottingham Law Centre, and I happened to see what the SRA requires as client care letters. I couldn't understand them, and they didn't seem to comply with the SRA. If I can't understand them, then I don't think the average person who's retaining legal services can. So I guess what I'm saying in a nutshell is there is a lot that can be improved, but I think having 11 regulators who don't communicate with each other, who don't share the data, who seem to focus on micromanaging and miss opportunities for early intervention to really protect consumers is part of the problem. One of the final recommendations in our report was, in the longer term, to look at having a more simplified regulatory environment so that consumers' rights could be better protected than the current regime. This is an inquiry on access to justice. This is a personal opinion, but I have seen very little appetite from the regulator in relation to improving access to justice. They commissioned the report, and the Legal Services Panel have been working very hard alongside myself to get those recommendations adopted and implemented. The question I keep asking is, why can it be possible to do things in other jurisdictions and it's not possible here? And so I guess what I would say is, I think that having too many regulators, there is a lack of direction, a lack of strategy, and a lack of understanding who they are here to serve. And so that is a response. So I would go further than Tom. Yeah.
Thank you, that's very helpful. Samantha.
Thank you. So you've touched on some of the things that I wanted to ask you anyway, but just so if we're looking at the Legal Services Act 2007, the board and the approved regulators, they've got an objective, which is to improve access to justice. And I just wondered, firstly, how effective that's been. Your face says it all. I don't think we need to answer that question, perhaps. But it was
not good at poker.
That's right.
We do spend quite a lot of time trying to remind them that is their major statutory objective.
That's disappointing, isn't it? Okay, so you submitted some evidence, I think, Tom, it was you, that said that the regulators were reluctant to even consider how their levers might be used in a more creative manner. Why do you think this is? Why is it so flipping difficult?
I wish I knew. I think that part of it, I think, is because in relation to the individual regulators, some of them are very small. I find it really striking that even the SRA is only responsible for regulating a couple of 100,000 professionals, and some of the small ones are regulating fewer than 1,000.
Fewer than 1,000?
Fewer than 1,000. And what does, if one was reinventing or revisiting the Act, I suspect you'd have a single regulator with maybe some special interest groups to address the special interests of cost lawyers or whatever. But
yes.
I think there are some questions about the structure of the Act. I think there's a big risk, and it's actually embedded in part in the current two-tier structure, almost three-tier structure if we include the professional bodies as well as the frontline regulators, with a degree, at least in theory, of the people who undertake the regulation being beholden to the professional bodies, so Law Society to SRA, Bar Council to Bar Standards Board. That is something I spent 13 years as an NHS Trust Chair and involved in NHS governance before that, which in relation to the other statutorily regulated organisations went away 20 years or so ago or so, but for some reason or other, when the 2007 Act was passed, that two-tier structure remained.
Can I add to that? I'd refer you to paragraph 4.5 of my submission on page 18. And this is the view that I've expressed in my submission to this inquiry. The current composition of the LSB, and I would say some of the other regulators, is predominantly drawn from backgrounds in regulation, audit and risk compliance, with limited representation from those with direct experience in access to justice service delivery, lived experience of disadvantage or expertise in innovation and funding, without a substantial shift in the organisational culture, personnel and strategic focus, specifically one that prioritises access to justice as a core objective and develops a robust action plan to fulfil its statutory duty, the LSB is unlikely to serve as an effective and credible steward.
Can I just ask, and maybe I've not picked this up somewhere, but that no doubt has been seen, and I wonder whether there'd been a response to your criticism.
No. I have to say that the current CEO did, while I was on holiday in Rome last week, did send me an email inviting me to give a submission to the current consultation, and one of my colleagues who I wrote the report with will do that, because my area of interest is access to justice. And I've got to be focused on that because there's 3.8 million people relying on me to improve things. But the other thing I would say is Lord Bark, who launched the regulatory report on leadership and access to justice, he asked me before the launch if I could look at all the recommendations in our report and look at the things that Parliament or government could do to support the regulatory improvement. And I attached to the submission policy brief one. I've slightly adjusted it now, but I think one of the other issues is I think the actual overriding objectives are I think there should be a paramountcy. I think the rule of law and the public interest, and I think the sub-postmaster's incident is an example of how it can let us down. I think there's an overemphasis on the commerciality of the legal profession, and I think there's an overemphasis on the best interests of the client, which might serve the individual but doesn't look at the broader impact on justice and particularly on consumers and the individuals. So I would refer to that, and that I had an incredible assistance from an expert in that area as well. So that's a reform, going back to your original question of the Legal Services Act. But that is what happens in Australia, and in the policy brief I talk about that. And the other thing about that is it shifted the culture of the profession and the regulator as well. So when we're talking about a long-term shift, flowing from that has been a greater concern with consumer protection, ethical conduct and access to justice. I don't think they're either or. I think when you do and enhance those things, they help each other and support and scaffold each other.
I want to just say one thing in defence, actually, of the regulators. What we have seen in the last couple of years is an investment, particularly by the SRA, actually in sort of the consumer-facing, consumer-oriented staff there. We are getting some very good cooperation from them at the moment. So these things ebb and flow. However, it shouldn't be just dependent on whether the right individuals are in post or not. And I think there are some problems between that. And we can understand it in the context of the Post Office, SRA, SSB, Axiom Ints, the very, very big concern about trying to protect or address the issues of regulatory oversight, where there clearly have been some shortcomings. Whereas actually what we're wanting to say is we'd really like to see regulators taking a view that they have a duty to try and, if they're going to deliver access to justice, look at being innovative about how they might do it. And that raises really interesting questions when we look at things like the Mazur case and what the implications are for making the market for particular specialist services work better than they do at the moment.
Yes, one of the questions is how much does the public understand any of this, and the regulators and their purposes and all the rest of it, and that probably is in my view, and I don't know, I'll ask you, but that seems to be a signal of failure. If people don't understand, then that's lost, isn't it? That is.
I think one of the challenges for the regulators, or in whatever shape or form they are, is to engage with public legal education. as a kind of coordinated strategy across the board. Because one of those, we're never going to address and overcome the intrinsic asymmetry of information and knowledge. It's just the nature of kind of professionalism against the consumer. But I think we could do a better job with greater investment in legal public education. And that comes back to the concerns about the lack of progress made with the regulatory information system, which was recommended by the CMA report back in 2017. Those of you who study the legal pages of the Times will have seen the article I wrote in early last month, exercised by the fact that less progress is there. But part of that should be a part of that platform is something which would assist the consumer in understanding what it is when they're needing to engage a lawyer.
Yes, and how they choose. So how general members of the public choose the provider that they need. Okay, that's brilliant, thank you. I think probably I'm going to hand over to Vicky.
Yes, just before you do, I should just say for the record that we've had a couple of references to Mazur so far, and normally we don't mention cases which, or certainly don't discuss cases that are literally in front of the Court of Appeal as we speak. However, we have been granted a sub judice waiver by Mr. Speaker, so we can make reference to the case, just for the avoidance of doubt. Becky.
Thank you, Chair. I think I'm going to direct this to Tom, because I think we know Liz's answer. Just to sort of set the scene about whether regulators are doing enough to protect consumers. Obviously, there's a difference between them having enough information, but in terms of protecting them, sometimes from their own decisions, how good a job is the regulator doing, and what advice, what suggestions would you have on that?
One of the things I was slightly anxious about there was, within your question, was protecting. You said protecting them from the outcomes of their own decisions. Is that protecting the public?
Consumers. Obviously, we talked about them making a choice about how they access their justice, and actually not really understanding how they're accessing the justice. And therefore, how does the regulator protect the consumer if the consumer doesn't understand what it is they're buying?
Well, I think one of the big problems actually is needing to protect the consumer from the legal professional who is not conducting themselves in what I think the general public would regard as being professionally. So if we think about the Post Office Horizon scandal and how most of the lawyers there ended up taking a view that their duty was, famously it was the dispute between Paula Venables and Susan Crichton, where Susan Crichton, to her credit, stood up and sort of said, my duty is to the law, not to the post office. And Paula Venables is alleged to have sort of said, no, your duty is to the post office. So you've got that. We've got the really quite egregious defects in terms of poor conduct by the lawyers at SSB and Axiom Inc. We have people engaged in some of the sort of volume claims, ambulance chasing type work. Now, that doesn't mean to say that there isn't a place for things like no win, no fee, because actually the post office sub-postmasters would not have had access to justice had they not been able to access it. Yeah. However, there is a question about how the regulators protect the public from poor conduct or even sort of dysfunctional conduct as opposed to sort of egregiously unprofessional conduct. The question then of how you protect the consumer from making poor decisions. I'm slightly reminded of the chief executive of Heathrow, who was complaining about congestion at Heathrow being a consequence of passengers at Heathrow being in the wrong place. I'm an ex-retailer, and one of the things you learn in kind of consumer marketing world is it's not the consumer's fault, it's your fault for not providing the right service in a way which addresses them. That being said, I think there are things which can be done to protect the consumer, which is just making sure that everything is clear and transparent, I'm of an age where I'm just about to take advantage of a pension scheme, and actually the way that I've been serviced by the financial services provider is exemplary in terms of making sure that I have considered all the right sorts of issues.
Right.
I am not confident, and the evidence suggests that it's not generally kept and delivered in the same way across the board. That's not to say that there aren't most solicitors and most barristers and most of the other legal professions don't do their job very well and very professionally, but too many instances where they don't.
We've recently had some evidence regarding the ease at which people can end up entering, these arrangements, often maybe no one, no fee. Now that they can, see an advert scroll as they're scrolling, in bed, and they click on it, and before they know it, they're in.
Yep.
So I just wonder whether you think the regulators are attuned to the different ways people are. It used to be that you'd have a newspaper, wouldn't you, and you'd have a big advert, and all the small print would be there. You might not read it, but it was at least there. Now it feels like you've pressed the button and you've started on a journey that you can't get off. Do you think the regulator's up to date with the way people are engaging with legal services?
I think we have a big debate taking place about whether or not, about application of technology. And actually in lots of cases we do lots of stuff, we buy holidays and so on online, or large proportions of the population. I think there's room to do more using technology, but at the same time we then need to protect the interests of those vulnerable consumers who are less adept at coping with it. And it's a significant part of the work we do focuses on the issue of the vulnerable customer, as opposed to the customer who just has the disadvantage of being on the wrong side of an asymmetric relationship.
Okay. And just touching on the no win, no fee, why do consumers who sign up for no win, no fee claims sometimes end up owing thousands of pounds in legal costs? I thought that was the whole point, was that wouldn't happen.
Well, that certainly is what it's the small print is the issue, and I think the question there is what the rules are that surround those sorts of deals and what protection there is for the public in terms. So I think for markets to work effectively, you actually need good regulation. One of the challenges we've got at the moment is that there's a very sensible, reasonable appetite. I spent last year, as some of you may know, as the COVID Counter-Fraud Commissioner working in Treasury, where I was hearing an awful lot about what regulations can we get rid of, and a lot of regulations may be unnecessary. However, for good markets to work, particularly where you have a market failure, which is what you have, wearing the kind of economist hat, where you have that imbalance of information. If we had a better informed consumer, and consumers never going to be better informed at our end of the market, because we engage with these things. I have had the good fortune to live in the same house in Andy's constituency for the last 42 years, and I may have one more property transaction in my life, having never done it again. So I've had the benefit never of having had to be involved in criminal proceedings. So if I had to retain a lawyer for that, it would be a first for me. I'm the executor for a couple of elderly relatives' estates. When I do that, that will be the first time. So inevitably, and this is the nature of legal services, is that most of us engage with it very rarely, so we are not expert. And consequently, there is a need to find ways to protect the public when they are accessing those services. Otherwise, we really are innocents abroad.
Do you think that legal service providers do enough to help consumers make informed choices? Because you're right, it's not the consumer's fault. It is either the provider or the regulator who provides the framework for the provider. So is enough being done at that middle level?
The answer is I don't know. Okay. I suspect not. And I think one of the really important things is not to look at legal services as being a discrete industry. Financial services has very comparable challenges. And I think there may be some models where we can look at seeing what happens.
And
there.
they have a specific duty as well, consumer duty, that the legal, as we say in the report, that the legal regulator doesn't have. Can I just add to Tom's?
Yeah.
There is significant amounts of research, and I did an ARC project across the UK and did empirical research where we talked to frontline services and frontline service users. The other thing I think we can't ignore is there's a significant power imbalance that operates between consumers and their lawyer. There is a feeling that the research reveals, and I'm talking empirical research, where you're actually talking to the consumer, not just what lawyers think, people think, where they feel that they can't do anything and they're already disempowered by the whole process, and they think that they're lawyers, so they know the law.
Yeah.
And I think that that's a significant thing we can't overlook. So when a lawyer tells you something, for example, using some of the examples, when a lawyer writes a letter, say a debt collection letter to someone saying they owe money that they don't owe, because it's on legal letterhead and it's a lawyer's letter, it works the other way too in my experience. When you go into the DWP with a lawyer on your team and they suddenly fold and they give your client what they want, and that's from my research. But the issue is a lot of consumers tend to think that the lawyers know the law, therefore I must be wrong, and I am afraid of reprisals because I'm relying on the lawyer for my other help, and so they think a lawyer knows the law. So what the solution, I think, is more needs to be done to, as Tom said, have more transparency and use of plain English,
Right.
which lawyers do not like because it justifies them charging for the opaque language they use. Sorry. But also more, yeah, well, I'm a lawyer of 30 years practice, so, but also it needs active regulation. And one of the things, again, in the report that we argue for is there is a really missed opportunity in CPD. Lawyers in Australia, for example, in order to keep their practicing certificate, be they a barrister or a solicitor, have required to do mandatory areas of CPD, which don't just rest with the Bar or the Law Society, but regulators can play a role here in terms of what good practice is and is not. That includes good ethical practice, that includes how to communicate with clients, trauma-informed practice, dealing with vulnerable groups, people with intellectual disabilities. They also have legal problems. Let's not forget about the sorts of community members we are talking about here. Consumers aren't some homogenous group. They're made up of people with disabilities, people who can't speak English as their first language, people who've experienced trauma, people who are overwhelmed, reference to Hazel Gen's work on referral fatigue. So there's also a landscape, which you've heard from the advice sector, where it's very hard because of legal advice deserts and the limited number of lawyers doing certain areas of work, the stress the charity sector is under. I'm involved, I'm academic advisor to Central England Law Centre. They've got 6 health justice partnerships, which is a great model. But all of these things are impacting on community members, and they don't often have one problem, they have multiple cascading and intersecting problems. So the regulator and the legal profession could do a lot more, but I don't think the training of the legal profession, either at law school or as continuing professional development, is good enough. And it could be led by the regulator. That's a wonderful opportunity for the regulators to really do something. And it goes back to public legal education, but professional development is key.
I think it's very tempting to actually say the legal profession. There are many good lawyers out there doing great stuff, public-spirited, etc., etc. So I think it's important not to lose sight of that. But I think there are questions, and I think it's an interesting one. Going back to the chair's question about what's changed, is the degree to which, and I'm no expert in this, that the opportunities for qualifying as a lawyer have allowed for a narrower base of legal knowledge, which means that the exposure of lawyers to some of those areas of underserved law, which even means that if we're looking at people wanting to go and do pro bono work, they don't have the skills and knowledge to be able to support sort of welfare law or housing law, because actually you may want to go and take your break from working for a magic circle firm and go and do your little bit, but actually you've got to that point in your career without having the knowledge which a generation ago you might well have done.
Right.
So there are some interesting questions about the mix of
Just the
stuff.
final thing from me then is, you talked at the beginning about there being so many regulators. If there was fewer, or a regulator that then had sub-regulators, would that make this CPD and this sort of engagement and the landscape of how consumers engage with the system easier?
Coherent, strategic. You'd have data in one place, perhaps even research and some evaluative work, and then that would shape and inform improved practice. Absolutely. At the moment, with 11, it's a dog's breakfast, to put it mildly.
Yeah, we have to support and encourage SRA to share its knowledge and support with the smaller regulators and vice versa. And it would be easier. It wouldn't be. I think it would be transformative, though.
Yeah.
Just before I go to Matt, Sarah, do you want to come in?
Yeah, so lots of what you said resonated with me. Lots of it.
I'm going to have to ask you to speak up a little bit.
Sorry, I was just saying lots of what you've said already resonated with me, but particularly one of the things that you referred to, I think, was lawyers' use of language. And particularly in engagement letters, I think there's a real problem with people not understanding what they're signing up to. And I say this as an educated middle-class woman who has helped various of her friends to understand the legal advice that they're receiving. So I'm not providing that advice, but I'm making sure they understand what they're signing up to. And this is usually other educated middle-class professionals who don't understand what's being put in front of them. So they're not the people who are suffering from multiple disadvantages in the level of life complexity that you're referring to, Dr. Curran. And I was wondering, does the SRA do any proactive work that you're aware of in looking at people's engagement letters?
I think that's a question to ask the SRA when they're with you, actually.
Happy to.
But it is, I think there are some really big concerns we've got around some of the things that get in the way of access to justice. Perversely, there are adverse consequences of well-intentioned stuff. So, for example, if you are wanting to retain a lawyer for a small piece of work with whom you don't have an existing relationship, the sort of know your customer requirements, which are there for very good protective reasons, anti-money laundering, etc., there are some questions about proportionality of that. And while, yes, and our job is to speak for the consumer, if I'm told by the high street lawyers that actually it is prohibitively expensive to do that for us to take on someone who's wanting a few £100 worth of advice, there is a bit of a concern as to whether or not we've actually overcooked something. And proportionality, I think, is quite important when you're looking at the access to justice at that kind of low budget end of the market.
Thank you, Chair. I'll just push back a little bit on the pro bono conversation there. As a layman, I'm not being a lawyer, I would have thought CPD is obviously important for solicitors and barristers and lawyers. So are lawyers themselves required to do enough support or enough to support access for justice, for example, through the pro bono work? And
I might tackle that one.
You've got the international comparisons.
Yeah, I do. And also I would say some lawyers, taking Tom's point before, there are some lawyers, and we wouldn't be able to survive the law centre movement, and other citizen advice and others wouldn't be able to survive without amazing pro bono efforts from a lot of the law firms. So I want to acknowledge that, and I also want to flag that properly funded legal support services is important first, and I could earmark there are other ways to get funding given current restraints, which I think are completely underexplored in this country and could really make a difference, and I'm living proof of that. I've run a law centre, I've been the beneficiary of funds through INCLA, I've evaluated programs. I just finished a 3-year and then a 10-year program, an innovative, all funded through funding interest on tax. So that's another issue. Pro bono, there are a lot of law firms that do a lot of government work. Policy Brief 3 that I've attached to the appendix is on pro bono. I have a lot of experience from Australia and a little bit from Canada in the pro bono. I would say that there is a really big missed opportunity in the UK at the moment. There are a number of law firms, large law firms, that do not do pro bono work, although there is no data and research on this, so that would be a point I think should be explored. I'm looking at solutions. We have 3.8 million, I think at least, who miss out on legal help when they need it. We have a lot of government work that brings in a lot of money, and I worked with the Victorian Attorney General in Australia in the 1990s through to the early 2000s and pushed, and finally that government agreed to mandatory pro bono with targets and with research sitting behind it on pro bono. And I must caution, it took us a while, and I was involved in these conversations as well, not only in Victoria but Australia-wide, for a really good working definition of pro bono, because that's really important. So in Australia now, not just in Victoria, it was started in Victoria with the Attorney General Rob Hulls. He introduced mandatory pro bono for all government work. Over the course of the last 20 years, it has led to a shift in culture in the legal profession, where they are really generally committed to improving access to justice, where they give student opportunities to work in, where they've developed also their own in-house pro bono units, and they have learned not to be an impost, and that would be the other thing I would say on law centres, because you don't want everybody saying, all right, we're here to do pro bono and how can we help, when the law centres can't even keep the lights on and they have to pay for security to have the pro bono. So pro bono can take different forms. But what I think is, if you are going to get large amounts of government work, for instance, the amount of money spent on a range of public inquiries and the range of lawyers who do that work and barristers, I don't think it's too much to ask, given the rule of law and equality before the law, for something to be given back. And so I think that I think that the charity model of pro bono is a problem. I think all lawyers sign up to the rule of law, and they are lawyers and upholding the legal system. And at the moment, we have the big end of town able to use the courts funded by taxpayers, including the corporations and individuals there. But a lot of public money is spent on the work that these people do, when we have large sections of the community currently missing out. So I think that there is a real potential. I know the government has an appetite for looking at this. I would encourage it to do it. There are fantastic models from around the world, America, Canada, and I would argue Australia, led by the Victorian Legal Services Board in Australia and Commissioner and the other regulators. So there's a huge opportunity there for pro bono.
I've got to dissent slightly, I think, from that view, which is we're putting a sticking plaster on something which shouldn't be there in the first place. Yeah. We do have a problem in terms of the fact that, for better or worse, legal aid no longer exists, that we have a market that is failing, and I think there are some questions there where, if we were able to harness all the kind of other innovative stuff, that we wouldn't be looking to a sort of mandated pro bono model. And for that matter, while someone working on M&A for Linklaters may be super smart, may have the best of intentions, but they're probably not going to have, they'll have forgotten anything they might have done in employment law once upon a time, and don't have any qualification to look at housing law or welfare law. I think there is a question that it's not. To
clarify, though, the definition of pro bono is not just pro bono is not in Australia. It is not just direct legal service delivery. Pro bono takes multiple forms, and as I said, it's not a substitution for an adequately funded legal system and legal aid system. But it's one way in which you can shift a culture. The training, the cross-training, and we have a mixed model in Australia, which Scotland is piloting, and that I think would be a huge long-term aim in this country to improve. But what has happened is the lawyers, the pro bono lawyers, have enhanced their skill and their knowledge set because they work alongside the advice sector, and so they learn about how to improve consumer protection, how to communicate and improve. And it also has led to a huge keeping of lawyers in the large law firm because they love the pro bono work. So it has a lot of benefits, and I'd refer you to the policy paper 3. I think it's one of a range of a repertoire where we can put the things together because the unmet legal need in this country is so great. So we've got to find solutions and problem solve. So I think it's one thing that could be done really well. But again, I caution the definition of pro bono is really key here. It's not just about having lawyers in the commercial end of town giving housing advice down in the community centre. There are different ways the targets can be defined, but that means everybody's contributing, but it's not a substitute for good government funding or other sources of funding.
Thank you. And my last question, Liz, I think may primarily answer this, but from your cross jurisdictional experiences, which potential additional funding proposals would be most beneficial in improving access to justice?
Okay. I've got I think there are, on page 19 of my submission and 20, I list all of the things. It's a blend of Canada and Australia. I think at the moment, as you know, there's some work being funded by Nuffield in looking at interest on lawyers' trust accounts. I did flag that as a beneficiary of that money is reinvested. I have changed my view. I don't think the LSB is the right repository for that. It might be the Access to Justice Foundation because it's got the expertise. But that money has funded innovation in legal services. In Australia, it was that money and some of the other money collected by the regulator, which I would argue not here, and some of the residual funding for collective action and public interest purpose funds. Those money is reinvested and they make millions by reinvesting it, and that is given to only Access to Justice. It does not go into consolidated revenue in Treasury. It's earmarked for Access to Justice. So when I started the first Health Justice Partnership, I didn't start in 1975, but it started in 1975. It was the first one in Australia. Were it not for interest on lawyers' trust accounts and these other forms of revenue, including levies on professional bodies and practicing certificates, that money has been used to fund Health Justice Partnership startups. There are now 143 in Australia. They also fund integrated service delivery, so lawyers in schools. So this is about putting people who have legal expertise and knowledge into the sites where people are likely to turn to for help, because they won't know they have a legal problem, they won't turn up to the law firm. But if they are disclosing to their physiotherapist or their podiatrist that they're a victim of domestic abuse and their partner is sitting outside in the waiting room, then what they can do is get the lawyer to come in the back door, and while they're doing their podiatry, they can get the legal support to leave that partner. These are incredibly innovative models, and I was reflecting on this because the Legal Services panel have asked me to go on a panel next week. I was reflecting on all of the programs that I have been either been as a director of a legal service had funded or as an evaluator. Many of those programs, the funding has come from alternative sources, and often those alternative sources have led to the evidence-based practice that has then led to the Ministry of Justice or Department or Attorney General's Department to actually continue to fund it. So it's an incredible, powerful way in which we can increase funding when there are so many pressures on the system from the NHS, etc., education, SEND, etc.
I think we have to keep in perspective in relation to that, the two major sources of lawyers' balances. One of them is the kind of conveyancing element. And if we look at the Australian model, where PEXA has taken over basically kind of, automated, it basically has removed that need for money to be sitting in a lawyer's account. And it's, there's currently MOJ is consulting on this one. And I know that the Institute of Chartered Accountants in England and Wales will be pointing out that on probate, which is where the big sums are, accountants are not allowed to keep that money. And the interest goes back to the consumer. Right. So I think the focus, there is something about regulators and their role in fostering innovation. And I think there's something about the proactivity which we are pushing for. There are some really interesting models out there. I think you may have had presentations from Garfield Law about their AI-informed small claims activity. There are things which will be transformative in various forms, different mixes. And I spent many years in the NHS, as I've described, looking at what the mix of professions is delivering a particular service, and getting that right to find ways to get to improve access, and improving access is often finding ways of doing things more cost effectively.
And on that point, the Ministry of Justice, I'm on the Legal Support Strategy Group, and that's a privilege, and the team at the Ministry of Justice are really working hard at this sort of idea of mixed models of funding, innovation, and they have also commissioned some research on the different, as Tom quite rightly says, the different makeups of the different professions and what the interest earning account and the attitudes and the appetite. I think a real danger is if that money isn't earmarked for access to justice, because it just looks like it's a money grab by government, and I think it needs a bit of nuance. And there has been a real buy-in by the Law Society and the Bar Council in Australia because of the collaborative agreement that was designed, we talk about it in the report, by the Australian regulators, where they're all in it together, and it's not division, it's a strategy that drives it. And that, I think, is part of the problem here. We don't have a fundamental vision or a strategy and a collaboration. And at the moment, a lot of people are arguing against ILCA because they say it's going to make their firm go broke. But if that's it, then I wonder why they're running their business and what the regulator thinks about that, because I think that this is, I have to stress, we have more than 3.8 million people in this country who are not getting legal help. We have 9 in 10 people who think the law's a game that's not for them. So I really think this is, there are ways in which we can really progress things. We won't have time today, but the mixed model in Australia, longer term, I think is something where people get holistic support in a one-stop shop, and they don't have to go to different providers for different areas of law. If I am experiencing family violence and I want to escape my partner, I need housing advice, I need income support, I need safety, I might need family law advice. I want to go to one, like I did as a lawyer, I want to go to one place with a really good lawyer who then has a fabulous relationship with the profession, and I can support that person while they get that legal help. So I can do information, advice, legal education, law reform based on my casework experience, and I can work in collaboration with other non-legal services. That's the mixed model. It sits alongside a duty care model, and I think that longer term we need to realise that access to justice, it goes back to Tessa's really good point. People just want legal help. They want their problems solved. They don't care who does it, but they want quality service. They deserve a quality service. And I think all of these things are different parts of the pie, but there are great ideas out there. And I think that other jurisdictions have done it and do it to great effect. I mean, the Victorian Legal Services Board and Commission generates millions of money through their schemes, and they fund really good access to justice. Why not in the UK?
Thank you very much, Dr. Curran. As you just indicated, time is against us, I'm afraid, but thank you so much, both of you, for the time and the fullness of the answers that you've given. I'm not going to suspend the committee. I'm just going to change panels and welcome Dr. Sorabji. If you You're very free to go, but you're equally free to stay, send part of it if you wish. But thank you very much for coming along today.
Thank you.
Thank you for the opportunity.
Yeah, absolutely. And I must apologise, I have to get back to Nottingham, but thank you all and thanks for the great questions too.
I'm afraid I have an appointment to go and donate plasma in Twickenham. So it's... Thank you. John.
Welcome, Dr. Sorabji, and thank you for being here for the earlier part of the session, so you know what we've been discussing so far. We don't need to do our introductions again. I think you've heard them. Perhaps you would just like to very briefly introduce yourself.
And not to break the table. Sorry. I'm John Sorabji. I am an associate professor at UCL, and I'm the co-director of their Centre for Dispute Resolution. I was also the co-chair of the Civil Justice Council's Working Party on Litigation Funding, which I imagine is the reason why I'm here, although possibly not. In appearing today, and whatever I do say today, I'm not representing the CJC, I should say. I'm here in my own capacity.
Understood, but you bring a great deal of expertise, which we're grateful for. And we'll begin with some questions from Wirinda.
Good afternoon, Dr. Sorabji. I'm going to ask you about third-party litigation funding. Could you begin by just explaining the role that third-party litigation funding plays in facilitating access to justice in England and Wales, and would you also be able to quantify its significance to the civil justice system?
I think probably as a starting point to answer that question, the one thing to note is that we have an extremely odd approach to litigation funding, and probably an approach that no other jurisdiction would take. We have 3 different regimes governing litigation funding, and each of them have a different role where access to justice is concerned. And that's in terms of litigation funding for non-lawyers. We have a separate 2-part regime of litigation funding for lawyers, which are covered by conditional fee agreements, sometimes called no-win, no-fee agreements, and damages-based agreements. So in terms of non-lawyer litigation funding, sometimes known as third-party litigation funding, we have the 3 regimes. First of all, we have a statutory regime that was introduced in the Courts and Legal Services Act, which has never been brought into force, and was intended, I think, to be a backup for conditional fee agreements when they were first introduced. So in terms of access to justice, that doesn't play any significant, if any, role at all, because it's not in force. Then we have 2 further regimes, one of which was thought to be outside statutory regulation until the Supreme Court confirmed that it was within statutory regulation. And that is effectively third-party litigation funding, where the funder provides funds for litigation in return for a percentage of the damages. From 2004 to 2023, that was thought to be permissible at common law and to be regulated at common law, or rather not regulated, because there was no statutory regulation of that system. That I'll come on to how it plays into access to justice in a moment. And then there is a common law regime, which the Court of Appeal confirmed remains common law and not subject to statutory regulation, which is where third-party litigation funders provide funding for either for instance, for a multiple of the funds which are advanced. In terms of how they assist access to justice and their significance, it's been well understood, at least since 2004, when the Court of Appeal, in a case called Gulf Azov, accepted that the availability of this type of funding is necessary to secure access to justice, that they are an essential feature of the funding environment for litigation. And this is particularly acute where collective actions are concerned. particularly collective actions that are brought in the Competition Appeal Tribunal. In effect, actions which are brought there, specifically opt-out actions, those are the type of collective actions where the class who are not before the court but who are represented by the representative claimant don't have to voluntarily opt in to choose to be represented. They're represented unless they choose not to be. For that type of proceeding, it is essentially the only form of funding available, viable form of funding. Damages-based agreements are not permitted, and conditional fee agreements are not sufficient to fund this type of litigation, and it's a very rare case, vanishingly rare, that a representative party would be able to fund the litigation themselves through self-funding. So in essence, where access to justice is concerned, particularly for those low-value claimants where there are multiple claimants who are represented in a collective action, it is the only form of funding available.
So there was a time when third-party litigation funding was considered to be contrary to the principles of public policy, because you had a situation where a party that is not part of a lawsuit then seeks to benefit because of the recoverability of damages. So why do you think that that principle has now been changed, and do you think that third-party litigation funding undermines equality of arms?
Undermines equality of arms? Most people suggest it supports equality of arms, but okay. Let me deal with the first question first. Third-party litigation funding, lawyers funding litigation, was prohibited up until effectively 1990. One reason for that historically was that that type of funding from strangers to litigation was viewed as unethical, particularly unethical for lawyers to carry out. For third parties who weren't lawyers, it was viewed as meddling with litigation, stirring up litigation, which is something that society frowned on, particularly in terms of it could be used to bring abusive litigation, to harass people, etc. We saw a shift really from the 1990s for one specific reason, I think. From the introduction of legal aid following the Legal Aid and Advice Assistance Act, we had, broadly speaking, what was intended to be a comprehensive system of public legal aid funding, litigation funding. From the 1990s, and England and Wales is no different from a number of jurisdictions, very many jurisdictions around the world, we have seen a retreat from public civil legal aid. One of the counterbalances to that retreat has been the promotion of private sources of litigation funding. So if you're going to remove an essential limb of access to justice or reduce it in terms of public legal aid, what are you going to put in its place? And what was put in its place were private mechanisms. So through the Courts and Legal Services Act, we saw the private mechanisms for lawyers in terms of conditional fee agreements, of which there have been 3 different versions over the last 30 years. Again, not making it simple or easy for the consumer. And we also saw from 2013 the introduction of damages-based agreements, again for lawyers. And then particularly from the start of this century, we also saw, and the starting point for this was really, I suppose, commercial cases that were being brought in the early years of the noughties. The understanding, particularly by the courts, that there were litigants, claimants, who were not able to bring claims at all or pursue them effectively without a means of securing funding. So to give you an example, one of the trilogy of 3 cases that established third-party litigation funding at common law is a case called Arkin and Bouchard, which used to be the case that everybody talked about until Packard 2 years ago. And in that case, originally the claimant had civil legal aid. That was then withdrawn. His lawyers were working on conditional fee agreements, but the question was, how do I secure funding to get expert evidence? And it was that question really which was the starting point for the real development of third-party litigation funding. It was to enable a claim to be prosecuted effectively without any other available source of funding. And the courts of appeal, particularly during this period, accepted that third-party litigation funding from non-lawyers was an essential mechanism to help secure access to justice. And Lord Phillips, when Master of the Rolls, in both in Arkin and in the Gulf Azov case, made the point, which has been repeated by the courts since then, that the public policy of securing access to justice is now the paramount public policy. So whatever concerns there may have been historically about the provision of funding by strangers to litigation or by lawyers is now overridden by this overarching provision. In terms of the second question, which was, does third-party funding undermine equality of arms? I think my answer to that is no, it doesn't. It promotes equality of arms. And the reason why it promotes equality of arms is that for a funded party, first of all, it enables them to bring their claim and pursue their claim. So previously to that, in the absence of funding, they wouldn't be able to do so. So there's an inequality of arms there, inequality of access to the court. Secondly, once they are litigating, it enables them to carry out their obligations to properly prosecute the litigation effectively, so to gather evidence, to test evidence, to obtain expert evidence, to ensure that they have sufficient counsel, legal advice, representation, so that they can present their case in court effectively or in the Competition Appeal Tribunal. So I think on those grounds, it helps to promote equality of arms. And there's another argument that it promotes equality of arms as well, in the sense that when you bring in a third-party litigation funder, one of the things they bring with them is expertise in terms of how you budget and cost and finance a claim. Now, one of the problems with litigation, particularly litigation in England and Wales, is the high cost of litigation. So bringing that expertise is one way in which you can try to rein in or control costs and to budget costs more effectively, which helps secure equality of arms for both parties because it's bringing the cost down for both of them. At least that's the argument.
You mentioned that collective actions are the kind of cases where third-party litigation funding can be used. Could you give examples of any other cases where third-party litigation funding can be used? And also, we had a roundtable meeting yesterday on access to justice, and I raised the concern that you would have a claimant who doesn't get their full amount of compensation because part of that compensation is going to be used to repay the funder. Could you say a bit more about the opt-in and the opt-out scenarios? And would the opt-out mean that the claimant gets the full amount of compensation?
Okay.
Apologies.
No. Thank you. Okay, so which are the cases? Yes, primarily and essentially in the Competition Appeal Tribunal and collective actions, but probably insofar as the majority of cases which are funded through third-party funding, you will probably see commercial cases, business cases, where it's used. And the reason why it's used there, not on the same basis that it's essential, in the sense of you couldn't litigate without it, but in the way that it helps businesses litigate without diverting their resources from their business to litigation. So it helps manage their finances. So that would be another area. There is another area of use which was alluded to, I think, a little bit in the previous session, which is portfolio funding, where funders provide funding to a law firm, and the law firm then uses that funding to help finance a range of litigation, low-value litigation, for instance, mass volume litigation. So it works in those type of areas as well, in that way. Again, not as essential as in competition and collective actions. In terms of the second question about full compensation, I think the first thing to note in that respect is that we do not have and never have had a system where claimants receive full compensation in the terms of in the sense that there will always be a deduction to pay their lawyers, because even though we have what's known as the loser pays rule in cost shifting, so the claimant brings their claim, they succeed, the defendant then has to pay the claimant's legal fees. That's not 100% indemnity. There's always a gap. So the claimant will still have to pay their lawyers in terms of the difference, the gap between what is recovered from the losing party. Now, that either comes out of money they have already, or it comes out of their damages. So there is no principle of full compensation. So the question then becomes, in terms of third-party litigation funding, is the compensation denuded to such a level, because there's such a large kind of share of it which goes to the funder in return for providing the funding, that becomes problematic. And I think there are a number of points that can be made there in terms of the validity of third-party litigation funding. The first is that in terms of the damages which are secured by the claimants, either in an opt-out or in an opt-in, in respect of how much they get following the reduction to pay the funder, that is likely to still be more than they will achieve otherwise, because the comparison is not between what they would have achieved without the funder, i.e. say £100 without the funder, £20 with the funder. It's between £20 with the funder and realistically nothing, because the type of claims that we're looking at and the value of those individual claims are so low that they are never going to be otherwise prosecuted. They're not going to be brought before the court. So for those type of claims, there's going to be no access to justice. So what you're getting with this system is access to some compensatory justice, in addition to the vindication of the right itself, in opposition really to the right going along the lines of unmet legal need, which again was talked about a lot in the previous session. Access has been denied. There's no real difference in that respect between opt-in and opt-out in terms of what's received. But I think in terms of thinking about access to justice, we also have to not just focus on compensation, because compensation to a claimant is one of the functions of the civil justice system. And promoting access to justice is not just promoting compensation, it's also promoting deterrence. It's promoting regulatory compliance, because defendant corporations, assuming they have done what they shouldn't have done, because they are now aware of the fact that proceedings can be brought against them, that they can be held to account for their tortfeasing, if they're tortfeasing, that helps to promote deterrence. So it helps to promote rule compliance with the law. It helps to ensure that individuals do not suffer from legal harm in the first place. So you have to also think about the deterrence function. You have to think about the regulatory compliance function. You also then have to think about a further aspect of access to justice, which is that court judgments which clarify the law, which show that this is how the law is applied in this type of circumstance, are, even if they're not precedents in the classic Court of Appeal Supreme Court sense, are means to guide lawyers and guide individuals who hopefully have access to legal advice effectively, in order to order their affairs effectively within the law. And also companies can do the same thing. So again, it's access to what you could describe, or what has been described as preventive justice. So when we think about, or when the committee is perhaps thinking about access to justice, I know you said earlier that it's looking at access to justice in the broad sense. That broad sense, I think, should cover preventive justice, consensual justice in the sense of consensual settlement, so alternative dispute resolution as well, because again, knowing how the courts approach these cases, which have been brought by claimants, which have been funded, and which have succeeded at trial or even have settled, guides future cases and disputes in terms of how they may want to settle their case. So it's access to consensual justice as well as access to compensatory justice.
Yeah, I take your point on that. From what you've said, are you also suggesting that third-party litigation funding is more likely to be used in lower value claims?
In terms of the collective actions, the answer to that is yes, because generally what you're looking at in those type of cases are individually low value claims that wouldn't be capable of being litigated economically because they're of such low value. And to give you an example, it's a classic example about why we moved from a solely opt-in system to collective actions to an opt-in or opt-out system. And that was the JJB Sports litigation, which arose maybe about 15 years ago. It might be longer now, which is showing my age, in terms of price fixing for replica football shirts. Now, I think in that situation, the individuals who fell within the opt-in class all had potential claims of about £25 each. And there are about 2 million of them, around about 2 million, I think, in the potential class. Nobody is going to litigate a £25 claim individually. First of all, they're not going to do it because it's so low, but secondly, they're not going to do it because the cost of doing it in terms of financing and time, they're not going to do it. So the only effective way that you can litigate these cases is through some form of collective proceeding. And the only way that you can effectively fund those is through litigation funding.
I've just got a couple more questions. This time on the Supreme Court's decision in Packard.
Yeah.
You confirmed that you're not here as a representative of the Civil Justice Council, but what would be your explanation as to why the CJC recommended that that decision should be reversed?
So, I think the primary reason that the CJC made the recommendation, or behind the recommendation, is that, first of all, the Packard decision is an interesting one, in the sense that it took nearly everybody by surprise. The only person it probably didn't take by surprise was Professor Rachel Mulheron, who I think in 2014 raised the question of whether litigation funding agreements, third-party funding, fell within the damages-based agreements regime, although she dismissed the possibility for a number of reasons. But it came as a surprise to everybody else. And it did so, I think, primarily because it rests on the interpretation of legislation that I think the view that was taken was that legislation only encompassed litigation funding because of the extremely broad drafting of the relevant provisions in FSMA, i.e. the definition of what is a claims management service. And that particularly broad definition, I think it was Lady Rose in her dissenting judgment described it as so broad as to be meaningless. It's not often you hear a judge describe legislation or legislative drafting as so broad as to be meaningless. In other words, it could encompass anything. And I think, if I don't unfairly characterise the majority in Packard, they also took the view that it was so very broad, but they took it that it wasn't meaningless, but that it did what they said it did. And I think the problem with that drafting had already been demonstrated. There was a concern in around about 2017, 2018 that the drafting was so broad that it turned expert witnesses into claims management service providers or services. An expert witness is not providing a claims management service. They are a witness. And there had to be clarification to the legislation to make it clear that expert witnesses were not within the scope. And I think I can say that the CJC probably took the view that it was only because of infelicitous drafting that litigation funding agreements were brought within the damages-based regulations. Infelicitous to such an extent that the government and Parliament didn't expect it, because when the Consumer Rights Act was going through, which introduced opt-out proceedings in collective actions, and also prohibited the use of damages-based agreements for opt-out collective actions. If it had been intended that litigation funding was a DBA, then Parliament would have been creating a form of procedure that could not have been used because there would be no funding available for it, because they would have prohibited the only mechanism to secure such funding, because at the time everybody used percentage-based damages-based agreements, damages-based litigation funding agreements. I mean, it was clear within the run-up to the legislation, the consultations on the Consumer Rights Act, both referred to damages-based agreements in terms of a damages-based agreement refers to the situation where a lawyer is paid out of damages. Not a lawyer and a non-lawyer, but a lawyer that is paid out of damages. In the explanatory memorandum to the Consumer Rights Act, it says damages-based agreements are where the damages are paid to the legal representative, not to a third party and the legal representative, but to a legal representative. So I think the view was that it was an unfortunate circumstance or eventuality arising because of poor drafting, or it's an unintended consequence, I think. And given that from 2004 onwards, funders, claimants and defendants had operated on the basis, defendants maybe not so much, but claimants and funders had operated on the basis that it wasn't a damages-based agreement following 2014 as well, that that legitimate expectation, however it may have arisen, wrongly as PACCAR would suggest now, ought to be put back into place. So I think those were effectively the reasons, or might be behind the reasoning.
Final question for me. The government has said that they will take up the CJC's recommendation to reverse the PACCAR decision, and you're satisfied with the government's proposals to proceed on that basis? Take it. Or have you got any comments to make? Yes, I entirely agree with the acceptance of the primary recommendations. Absolutely. I mean, the one qualification is, of course, that in saying that they will take forward the first primary recommendation, which is reverse PACCAR, the government has said that they only intend to do so on a prospective, not a retrospective basis, whereas the CJC recommended both retrospective and prospective. So that would be the one caveat I'd have on saying I support the position that the government's taking. I would hope that the government, as it has said, I think twice now in written ministerial statements, that it views this as a priority, that priority will translate into legislation sooner rather than later, because there remains uncertainty in the marketplace. I would also have that caveat. You would want it to be retrospective,
Yes,
as recommended by the CJC.
Yeah, and as the initial litigation funding bill from 2024 was intended to be retrospective and prospective as well. And I can't see the principled reason why there should be a change of position now. I mean, it may well be that the view is taken that retrospective legislation is generally not something which is done for various reasons, although I do understand that, at least from what I read in the newspapers, that the proposed legislation on jury trials is intended to be retrospective, so there perhaps isn't that much of a commitment to non-retrospectivity. Equally, in this type of situation, there remains a great deal of uncertainty as a consequence of it not being of legislation not coming in and it not being retrospective, because not all agreements which fell foul of PACCAR have been renegotiated. There are some situations where you might have restitutionary claims arising out of those agreements. So I don't think it's as clear as to say, oh, perhaps 2 years has gone by, 3 years has gone by, so therefore everything's sorted out and we can leave the past to itself. I don't think that's necessarily the situation. And the third point, I suppose you could say, is that it may be that there's a concern that there might be ECHR issues in terms of retrospectivity, although in that sense as the litigation funding bill in 2024 was certified under Section 19 of the HRA as being ECHR compliant, what has changed in those 2 years to make what was compliant then not compliant now. So for those, I think those reasons, I would still say make it retrospective if you can.
Thank you, Dr. Sorabji.
Can I ask you, in relation to, well, who and how should regulate third-party funding? The CJC said it shouldn't be self-regulation. We heard, I think, earlier on whether it should be legal service regulators who have oversight. How do you think that should happen? Because we've had some disasters in the near past. So who's going to protect the interests of the consumer there?
At the moment, what you have is regulation for percentage-based litigation funding, which falls under the damages-based agreement regulations, and then you have the rest, which is unregulated, or rather self-regulated, or it depends on your perspective whether self-regulation is non-regulation. And that self-regulatory mechanism only applies to some litigation funders because it's voluntary, so it doesn't apply to all litigation funders. So that's the first point. In terms of who should take over, well, the CJC recommended a two-stage approach to regulation. And the first stage would be to have the Lord Chancellor regulate litigation funding, which appears to be what the government intends to do, because that forms the second principal recommendation that the CJC made. And that would be through the Lord Chancellor issuing regulations governing third-party litigation funding agreements, which in fact was the original intention under the Courts and Legal Services Act approach, which sits on the books but still not brought into force. So Lord Chancellor, but that was, the CJC suggested that would be for 5 years to see whether that form of regulation worked. If at the end of 5 years the review was suggestive or took the approach that it wasn't working effectively, then we recommended that the Financial Conduct Authority should become the regulator. So not the legal profession, the FCA, because the FCA have the greater expertise. It could be said, and that was said to the CJC in some of the submissions to it, that they have the greater expertise in regulating financial instruments, and third-party litigation funding could be viewed as a financial instrument in some ways. So FCA as the backstop, with Lord Chancellor to do it for the first 5 years was the approach.
Is that another sort of window into the world of legal services regulation that shows they're not doing a very good job, or is that or could do better? The CJC did hear and did receive consultation responses in terms of legal services regulation where third-party funding was concerned. And that specifically focused on portfolio funding, which is where the funder provides funding to law firms to enable them to fund a variety of claims. And we heard that evidence, or those responses came in respect of the cases that you heard referred to in the previous session, which is SSB and Axiom, and also Pure Legal as well. So the mass volume claim firms, which were funded through portfolio funding, and the evidence that we were given, some of it suggested that there was no problem here at all in terms of regulation, and that was very much on the kind of like on the left field approach. But the main thrust of the evidence that we received was that this area of funding particularly was not regulated effectively. The solicitors' profession were not providing effective guidance, clear guidance to their clients, prospective clients, that the regulators, the SRA being the primary one in this respect, were not regulating this type of conduct, this type of funding arrangement effectively through the way they were regulating firms. And as far as I'm aware, the Legal Services Board
who know more about this than the CJC did at the time, because their reports on this area came out, I think, after we reported, concluded that yes, indeed, this is an area where there may be systemic problems in terms of effective regulation within the solicitors' profession, at least, which needed to be looked at and needed to be answered, including siloed working within the SRA, a lack of information transfer, a failure to properly recognise that the hundreds of complaints that were being made to them were not complaints about poor service quality, but were actually complaints which pointed to strongly systemic flaws within the effective regulatory regime. So, in answer to your question, yes, I think there are areas where legal services regulation needs to improve, which I think was one of the reasons behind the fact that the report suggested that, first of all, the government may want to look as a matter of urgency at legal services regulation, and secondly, that in terms of regulation of portfolio funding particularly, that be transferred to the FCA now rather than in 5 years' time, because that is in effect a loan. But where the use of that type of funding arrangement is in place, then there ought to be consideration of co-regulation between the FCA and the SRA to ensure that the right expertise in terms of regulator was brought to bear. So a little bit like the points that Dr. Curran was making, that there needs to be a more coherent, cohesive, holistic approach to regulation. So the CJC took that view, and as I understand that the Legal Services Board has endorsed that position in terms of FCA regulation and greater cooperation between the SRA and the FCA. So yes.
Thank you very much. Finally, we go to Tesla.
Yes, just two probably fairly swift questions. I was going to ask you about legal expenses insurance, and there's another face. That's all right. So, and just that's not so widely used, is it? No. And whether you might be in favour of promoting a case for expanding its use or not?
Well, I'm probably eccentric where legal expenses insurance is concerned. Maybe I'm in other ways, but where legal expenses insurance is concerned, because I would quite like to see serious consideration to be given to the introduction of mandatory legal expenses insurance. So everybody has to have it, so that we have better coverage, universal coverage for legal expenses. But I am, maybe I'm the voice crying in the wilderness on that. And the CJC didn't recommend that, I have to say. Although Sir Rupert Jackson did also consider the issue in 2009 when he looked at the costs of litigation. Where, in terms of a more mainstream approach, would be to legal expenses insurance, yes, we have a very poor approach to it. I think the statistics show that 8% of households in England have legal expenses insurance, 13% in Wales. I don't know Scotland and Northern Ireland figures. And that compares markedly to other jurisdictions, other European jurisdictions. So Sweden, 95% take-up of legal expenses insurance to be used before the event. So you insure yourself. And that came about as a...
Can I interrupt? Is that compulsory?
No, that's not compulsory. No, but as far as I know, nobody has compulsory legal expenses insurance.
It's 95%.
It's 95%. And that is a consequence of a clear government policy from the 1990s to move individuals from civil legal aid to an insurance-based model. So 95%. Now,
is it regulated, though? Is it value for money? Because I suspect that one reason why people don't choose to have it in this country is because they think it's a rip-off.
Well, I don't know about that. I think most people don't take out legal expense insurance because they think we're never going to have a legal issue. It's the same with... And the same argument was put forward in the US about mandatory health insurance. People don't take out health insurance when they're in their 20s and their 30s when they're fit and healthy because we're not going to need it. It's only when they need it when they're in their 50s that they can't get it. So people tend not to insure things that they think are never going to happen to them. But you never know if you're going to need legal expenses insurance. But in terms of the government policy, it was government policy to move people from a public funded system to an insurance-based system. In Germany, you have a 35% uptake of legal expenses insurance, and that's not because of a clear policy to move from civil legal aid to legal expenses insurance. I think 8% of claims in Germany are funded through legal aid, so it's much more in terms of legal expenses insurance than legal aid. In Germany, at least, there is a vibrant legal expenses insurance market, and one of the things which is said here is that we don't necessarily have a vibrant market, but vibrant markets can be created and nurtured. So I don't see why that ought to be a insufferable problem. At the moment, uptake in terms of legal expenses insurance is covered by household insurance. You have it as an add-on to your car insurance, to banking provision. You can take out mobile phone insurance and have legal expenses insurance. So it can be an add-on, and also in terms of business as well, they can add it onto insurance they have. Travel insurance, yeah, as well. So lots of people have it. In 2017, I think the Civil Justice Council, well, the 13% have it. In 2017, the Civil Justice Council did a report on legal expenses insurance, and one of the things that it noted then was that a lot of people don't use it, even though they have it. And then the question really becomes educating, first of all, those who have it to use it, and to make it usable, because there may be reasons why they don't think it's appropriate for their particular situation, but to improve the use of it, but also improve the take-up of it as well as a secondary. And one of the things that the CJC looked at in terms of improving the take-up was, what about the possibility of employers providing legal expenses insurance to their employees as possibly as a taxable expense to increase its take-up? Why not, in that type of situation, have it that it becomes an opt-out? So you're in the firm legal expenses insurance policy unless you opt out. Now, we know that most people never opt out of things. I'm still paying for insurance that I don't need 10 years, after the fact.
Can I just question, if I drill down into the Swedish example, so does that mean there is no, there would be probably no need, but people therefore buy flights without insurance, and they buy...
If they've already, I actually don't know the answer to that question, but I would assume the answer is that if they've already got expense insurance, then they wouldn't need to. But I actually, I wouldn't want to hazard a guess.
No, I'm just really interested. Okay, fine, that's a question for me sort of later. So can I know you said you weren't speaking on behalf of the CJC in any way, but their report did actually propose an access to justice fund. Through hammering the profits of lawyers and third-party funders through the conditional fee agreements and the damages-based stuff. So is there a coherent argument as to why those profits should be subject to some sort of levy?
So the idea there was that both lawyers and litigation funders are provided with the ability to make profits out of litigation through CFAs, DBAs, and through litigation funding agreements. So they're making a profit out of helping to facilitate access to justice. The quid pro quo for that would be that you help the state, you help the public to improve legal education and early settlement. So you gain from facilitating access to justice and the profits you make for it, and in that way you return something to society, which is the fact that you help to fund public legal education, you help to fund citizens advice bureaus, you help to fund consensual resolution services, etc. So what you're doing is you're not using this money to fund more litigation, you're using it to fund access to justice in that wider sense. So that was the rationale really for that idea.
Thank you very much indeed.
Privatising altruism.
I know.
This is what a good note to end the afternoon's proceedings on. Thank you very much, Dr. Sorabji. It's an extremely helpful answer. Thank you for coming to give evidence. That is all the business we have to transact today, and I will end the committee meeting here. Order.